What's up, foodies? So I have the answer and counterclaim for divorce and other relief from Jermaine Tucker. That's Todd Tucker, Kandi Burruss's future ex-husband slash... Never mind. I'll save that for later. All right. So Todd Tucker is being represented by Randall, a.k.a. Randy Kessler, who appears on Housewives of Atlanta here and there. He's represented Portia Williams, and I think he's represented some other people, but I know for a fact Portia Williams on Real Housewives of Atlanta. So he's a well-known attorney in Atlanta. And Kandi is using Phaedra Park's old legal assistant or something. Her experience in professionalism is kind of being questioned. So I don't know, but all right, I want to read this document to you guys because I did provide the document for Kandi's initial divorce filing. I'm sorry, initial divorce filing. So I'll tag that somewhere throughout this video, either at the end or as a link during the video. But before I do that, I wanted to share something I saw on the lead attorney's channel. And, you know, best wishes for him because I believe he has brain cancer. I don't know what the update is on that. But he tore Kandi's petition apart. He ripped it apart. So I'm going to include some little clips from what he had to say about Kandi's initial filing and Kandi's attorney. I am an avid Housewives of Atlanta and Housewives watcher, reality TV watcher. So yes, I'm not a legal beagle, whatever you want to call it. But I have, you know, interest in most things reality. So I may not know the legal jargon, but I know all about the mess and I know all about the history of Kandi and Todd. The lead attorney was saying Kandi's worth $30 million. Why is the paperwork looking the way the paperwork looks? When I was reading the document, I didn't notice this because, hey, I'm not a lawyer. But there's some things he points out in her initial filing that would scare us all. Kandi saying this thing was not going to be messy and they were going to be amicable in this divorce. But now Todd is basically saying he wants primary physical custody, and basically he's trying to get child support and alimony all wrapped into one. So let's look at a few clips from the lead attorney and then I will read the document. Okay, and then I'll come back with Kandi's rebuttal or amended document.
All right, so look at this. And I'll tell you what I look for now. Look at this, guys. I shouldn't even say this. I don't know this lady. I shouldn't do it like this. When I look at the first page, I already know what it is. Right here, it's instantaneous. Do y'all see what I see? What do y'all see that I see? Do y'all see? I see it immediately. Does anybody see anything? Does anybody see anything? I know exactly what I see. And I already know, I'm like, man, I'm going to tell you what I see. He said black names. Okay, here we go.
Really?
Here we go.
Jermaine.
Here we go. No, we're going to do the black names. So here's what I see. Number one, the formatting is fucked up. Why is the petitioner over here and the respondent over here? I already know what it is. This should be lined up over here. This is the first page and your formatting is fucked up, and this lady's worth $30 million. This attorney's office should be ashamed. No.
Well, they say she worth $30 million. She cheap. But is she really worth $30 million?
Listen, can I be honest? Y'all ain't gonna like this. But if this was a $1,000 divorce case, all right, man. You're sloppy as hell, but whatever. I'm letting it go. Because you got paid $1,000 for it. This lady worth 30 million and you fucking up the formatting on the first page.
Look at his face.
Let me get this straight. This lady, this black lady is worth $30 million. And this is how you're doing our sister right here? Also, look at this. Look at this. K. Lennis Tucker, the comma. There should be a comma right here. What do you notice? Does anybody see it? This is perfect. K. Lennis Tucker, comma. She's the petitioner, which should be right here. Does anybody see it? Look at this fucking comma way over here. I already know.
Grinding my gears.
I just looked at the first page.
All right, so he goes on to point out some other stuff too. And also another big thing, because I'm not going to play his whole video, is some kind of verification that was supposed to be filed, and Kandi didn't file, or the lawyer didn't file the verification. So I think she did have to come back and file it. But like, wow. Like I said, she used to work for Phaedra Parks, Esquire, who's also a cast member of Real Housewives of Atlanta. So I don't know how long she's been, practicing on her own, but she used to be like a legal assistant or whatever for Phaedra Parks. And y'all know Phaedra and Kandi, are at odds or don't get along. You'd have to know Housewives of Atlanta to know the history of that. But it's just funny that Kandi would hire someone that used to work for someone that she doesn't like or doesn't fool with, who betrayed her.
When I'm worth $30 million. Why is a paralegal working on my divorce complaint when I'm paying you $450, $550, $600 an hour? I'm paying you $600 an hour, but a paralegal is working on my damn complaint and fucking it up?
He'd be cracking me up.
I know I'm black. I know I'm a woman. I know I'm a black woman. I know how things are done in this country, but I'm smart. I got more money than everybody in this fucking office combined. So put some respect on my fucking complaint. Let's keep it going. Divorce complaint, sha-la-la, 6 months, she's a resident. See. What you don't do on the first page is number the first page 1. Why don't you put a number 1 on the first page? Does anybody know? The answer is because it's obvious that it's the first page. It's obvious.
Is that college paper 101?
Right? Good attorneys, they're like, hey man, you'll have a footer down here and it'll give the whole style of the case. What's the style of the case? This is the style of the case. So it'll say Kandi versus Todd, civil action number, petition for divorce, something like that. This is terrible. And guys, listen, if you got a $3,000 divorce complaint, if you pay your attorney $3,000, we ain't talking about this. Well, Lee, that's not fair. Listen, everybody in here is grown, and everybody in here knows that you get what you pay for. So I'm not gonna make any justifications about it. I'm gonna just say you get what you pay for.
So, Kandi, this is not the time to take the cheap route. This is not the time to be helping out, new and upcoming attorneys. The lead attorney goes on to say there are not a whole lot of top divorce attorneys in Atlanta, but there are some. There are enough for her to have chosen one. He also gives tips on how, you can call top attorneys and consult with them so that they are not able to work with the person you're divorcing. He gave that tip. So, maybe Kandi will change representation if she wants to come out on top in this, because I know Randy Kessler, Todd's attorney, is seasoned. She should have hired a seasoned attorney. I don't know how long this lady's been practicing Amde or whatever her name is. But come on, Kandi. Come on now. Now, the lead attorney also says that this could be a $200,000 case because of the amount of money that, they have or Kandi has or whoever has it. But yeah, even though this stuff seems minor, but it sounds like a big deal to me. You gotta verify your paperwork before you submit your paperwork. I mean, if the judge sees it, the judge is gonna scoff at it, I'm pretty sure. Everything is for the best interest of the kids, but still. He's saying the fonts are different. There should be a footer. The first page shouldn't be numbered. The stuff is not lined up. And then also another situation is that there may be a conflict because the person that's representing Kandi is also representing Kandi and Todd in their restaurant lawsuit. Is there conflict? Yes. And it can work to his benefit.
This might be a question where I might have to at least do some research. But after my research, I might have to call the state bar and let them try to figure it out. If I'm Randy, I already know about this conflict. But the judge is not going to say anything if I don't say anything. So if I'm Randy, I have to sit back and I have to say, should we get this attorney disqualified? And I have to talk to my client. I have to talk to Todd. I'm like, Todd, listen, I don't think Kandi's attorney can represent Kandi. Why not? Well, because you own companies and you, along with Kandi, have hired Kandi's attorney to represent those companies. And now she's representing Kandi against you. So kind of your own attorney is fighting against you. Well, she's not necessarily your attorney because she represents the companies, but she has access to information in that representation that may be used against you. And Todd might be like, well, I don't like that. Let's get her disqualified. Can we do that? And Randy might be like, yeah, we can get her disqualified. But what's the problem? See, marriage causes divorce. It's already, that's why he's a ringer, man. We need to do a damn show together. What does marriage cause divorce say? Marriage cause divorce says keep her in. Keep her in. Why would you want to keep her in? Does anybody know? Do I want her to go out and fire this lady and go hire the lead? Mm-hmm. Fire this lady and then go hire, what's the black woman who represented, she's awesome. 30 years in the game, I forget her name. She got like a 3-name name. There are great attorneys in Atlanta. There are great attorneys in Atlanta.
Okay, so basically don't worry about the conflict because then Kandi will go find a better attorney. The lead attorney also said that in this case, Kandi is like a Halle Berry and that Todd is basically seeking double child support. Like, so in essence, he could get alimony, even though Halle Berry lived in California and they're in Atlanta and divorces are easier in Atlanta. It's still the same situation where Kandi is kind of like the breadwinner and she's the male in the case and Todd is the female. So Kandi better look out. Kandi better watch out. Kandi better hire some proper representation unless she already knows, that they got this or that, in the end, maybe it will be amicable and everyone will get what they're supposed to be getting. But Todd wants, something from that house that was Kandi's before he came into the picture. And he wants to make sure they also split up their debt. So let's look at this document. Comes now respondent T. Jermaine Tucker by and through his counsel of record, Randall M. Kessler and Asha Hayward James of Kessler and Salamiani, and files his answer and counterclaim for divorce and other relief. Overview, respondent T. Jermaine Tucker, husband, and petitioner Kayla Niece Tucker, wife, that's Kandi, were married on April 4, 2014. On that same day, a purported prenuptial agreement prepared by wife's attorney was presented to husband. Without husband having counsel, even though wife's then counsel had communicated previously with the undersigned regarding a potential prenuptial agreement. The minor children are currently in husband's care and residing with him in Georgia, while wife's out-of-state work obligations have required and will continue to require her to be away from the children for at least the next several months. Several could be 3, but we know she's on Broadway, or going to be on Broadway. The parties have been working cooperatively in an effort to resolve all issues, and husband remains committed to continuing his discussions in good faith. However, in the hopefully unlikely event the parties are unable to reach a full agreement, husband shows that he will seek an award of primary physical custody, joint legal custody, and final decision-making authority, with wife having substantial time and meaningful access to the children. Husband wishes to make clear that he recognizes wife as a loving and capable parent and remains sincerely hopeful that prior and continued discussions between the parties will bring full resolution of all matters. First defense. Husband affirmatively shows that petitioner's petition for divorce petition is procedurally deficient under OCGA 1955. However y'all read that, y'all know I'm not a legal beagle. Specifically, petitioner failed to 1. Verify the petitioner as required by subsection A. 2. State the residence or last known address of respondent as required by subsection B1. And 3. Provide the name and age of each minor child as required by subsection B4. Husband reserves all rights to challenge the sufficiency of the petition based upon these statutory deficiencies. Okay. Was that purposely done by Kandi's attorney, or did she make an error? And if she made an error, that can easily be fixed. So that's why you petitioning it? Okay. That's why you're challenging it? Okay. Response to petition for divorce. 1. Husband admits the allegations contained in paragraph 1 of the petition. 2. Husband admits the allegations contained in paragraph 2 of the petition. By way of further answer, husband likely has or will execute an acknowledgement of service. 3. Husband admits the allegations contained in paragraph 3 of the petition. By way of further response, husband shows that the parties were married April 4th, 2014. 4. Husband neither admits nor denies the allegation contained in paragraph 4 of the petition. Number 5. Husband admits the allegations contained in paragraph 5 of the petition. 6. Husband admits the allegations contained in paragraph 6 of the petition. 7. The allegations contained in paragraph 7 of the petition require no response from husband as it contains petitioner's request for relief. To the extent that a response is required, husband admits in part of the allegations contained in paragraph 7 of the petition to the extent that the minor children have been in custody and joint control of both parties. 8. The allegations contained in paragraph 8 of the petition require no response from husband as it contains petitioner's request for relief. To the extent that a response is required, husband admits that it is in the best interest of the minor children for the parties to be awarded joint legal custody of the minor children. There's that footnote at the bottom that the lead attorney said Kandi's attorney should have put at the bottom of the original petition. 9. Husband admits the allegations contained in paragraph 9 of the petition. 10. The allegations contained in paragraph 10 of the petition require no response from husband as it contains petitioner's request for relief. To the extent that a response is required, husband admits in part that the parties signed a prenuptial agreement dated April 4, 2014. By way of further response, husband directs the court to husband's counterclaim for divorce and other relief for husband's further response to the allegations contained in paragraph 10, which response is incorporated herein. 11. The allegations contained in paragraph 11 of the petition require no response from husband as it contains petitioner's request for relief. 12. The allegations contained in paragraph 12 of the petition require no response from husband as it contains petitioner's request for relief. 13. The allegations contained in paragraph 13 of the petition require no response from husband as it contains petitioner's request for relief. Any allegations not specifically admitted to herein, 14. Any allegations not specifically admitted to herein are denied. Wherefore, husband prays that any prayers for relief enumerated in the petition be denied to the extent they conflict with the relief sought by husband. Counterclaim for divorce and other relief. Comes now T. Jermaine Tucker, respondent husband, by and through his undersigned counsel, and files his counterclaim for divorce and other relief, respectfully showing the court as follows. 15. Husband is and has been a resident of Fulton County, state of Georgia, for 6 months prior to the date of the filing of this counterclaim for divorce and other relief. Petitioner is a resident of the Fulton County, state of Georgia, by virtue of filing the above stated complaint. Wife is subject to the jurisdiction and venue of this court. 17. The parties were lawfully married on or about April 4, 2014 and are currently living in a bona fide state of separation. 18. There are 2 minor children born as issue of this marriage, to wit, A. Tucker, a male child born in 2016, and B. Tucker, a female child born in 2019, hereinafter minor children. 19. Husband shows that he should be awarded temporary and permanent legal custody of the parties' children, as well as final decision-making authority. 20. Husband shows that he should be awarded temporary and permanent primary physical custody of the children. In the event the parties were unable to resolve all issues privately, the court should determine all matters related to the minor children in accordance with OCGA 19-9-3 and 19-6-15. In accordance with OCGA 19-9-69, husband shows the following. A. The minor children have resided with the parties at the marital residence located at. B. Husband has not participated as a party or witness in any other capacity in any other litigation concerning custody of the parties' minor children in this or any other state. C. Husband has no information concerning any other custody proceeding concerning the minor children presently pending in any court in this or any other state. And D. Husband knows of no person not a party to this proceeding who has physical custody of the minor children or claims to have custody or visitation rights with respect to said minor children. In the event the parties are unable to resolve these issues or mediation or otherwise, husband requests that these issues be heard at the 30-day status conference scheduled for January 12, 2026, or in the alternative, that is, that this matter be scheduled for a temporary hearing at the court's earliest convenience to address temporary custody, parenting time, and all other temporary issues necessary to promote the best interests of the minor children and to ensure clarity and stability for the parties pending final resolution of this action. Husband is entitled to a divorce from petitioner on the ground that the marriage is irretrievably broken as defined in OCGA 19-5-3. 13, and there are no prospects for reconciliation. Husband is further entitled to a total divorce or divorce a vinculo matrimonio. Y'all, sorry. I am not a legal beagle. While husband remains hopeful that the parties can resolve all issues amicably and privately, husband expressly reserves the right to assert and add additional grounds for divorce as permitted by law. Husband shows that the parties signed a prenuptial agreement dated April 4, 2014, immediately prior to the wedding ceremony. Petitioner's counsel at that time was fully aware that husband was represented by the undersigned and had been actively communicating with his attorney regarding the terms of a potential prenuptial agreement. Despite that knowledge, petitioner's counsel presented the final agreement to husband for signature immediately before the wedding ceremony without any notice to or consultation with the undersigned counsel, who had been significantly engaged in the negotiation process. These circumstances raise substantial concerns concerning the enforceability of said document. Nevertheless, husband remains committed to working in good faith to resolve this matter amicably and privately to the extent possible. During the course of the marriage, the parties have acquired various assets known and unknown to husband, tangible and intangible. Husband should be awarded an equitable division of all marital assets, both real and personal, tangible and intangible, between the parties. So I guess you want her to start digging and see what all you acquired while y'all were married that she don't know about. Husband shows the court that he should be awarded his separate property and any appreciation thereon. Husband shows that the parties have acquired debt throughout the course of the marriage. Husband requests that such debt be equitably divided. Okay. Husband shows that OCGA 19-5-7 provides as follows with regard to the transferring of disposition of property. After a petition for divorce has been filed, no transfer of property by either party, except a bona fide transfer and payment of pre-existing debts, shall pass title so as to avoid the vesting thereof according to the final verdict of the jury in the case. Further, a wife is bound by the provisions of OCGA 19-6-1E, which provide as follows with respect to the transferring or disposition of property. Pending the final determination by the court of the right of either party to alimony, neither party shall make any substantial change in the assets of the party's estate except in the course of ordinary business affairs and except for bona fide transfers for value. Husband insists that petitioner comply with the foregoing statute in all respects. Petitioner is put on notice of not only the law, and petitioner is Kandi, by the way, y'all, put on notice of not only the law of the state of Georgia, but also on notice of husband's intent to insist on full and absolute compliance by petitioner. Husband hereby places petitioner on notice of the following important provision regarding spoliation of evidence. You are hereby notified that Georgia law requires you to exercise reasonable care to protect and preserve evidence relevant to the issues in this case action. By this notice, you are hereby given notice not to destroy, conceal, or alter any video, audio, paper, or electronic files or other data in connection with this pending litigation, including, but not limited to, any of the following items that are either presently in your possession or control, or which may come into your possession while this case is ongoing. Any financial records or statements, all income records, all tax records, all expense records, all recordings or evidence reflecting relevant conduct by either party, any item that supports any defense raised by you to this position and or any item that supports any claim made by you in any counterclaim or pleading filed in this matter. You are further notified that a failure to comply with this notice may result in sanctions for any destruction or failures to preserve any such evidence, including, without limitation, adverse inferences against you at trial, as well as an award of expenses and attorney fees necessitate by such conduct. Lane versus Montgomery Elevator Company, 225 Georgia, App 523, 1997. Spoliation or destruction of evidence creates the presumption that the evidence would have been harmful to the spoliator. That's funny to me. Greer versus Andrew, 138 Georgia. Okay, that's a bunch of cases and codes, y'all. Proof of such conduct would raise, and did Kandi's lawyer cite any cases? Proof of such conduct would raise a rebuttable presumption against Montgomery that the evidence favored Lane, a fact rendering summary judgment inappropriate. Okay, more case citation. Husband is hopeful the parties will reach an agreement settling all issues pending between them. However, if such an agreement cannot be reached, husband reserves the right to amend this counterclaim accordingly. Husband requests that the court incorporate any settlement agreement entered by the parties into a final judgment and decree of divorce. Wherefore, husband respectfully requests that a rule nisi issue requiring petitioner to show cause why the temporary relief requested in husband's answer and counterclaim for divorce and other relief shall not be granted. That he be granted a total divorce from petitioner upon legal principles, that is, a divorce a vinculo matrimony. Nay. That husband be awarded legal custody, final decision-making authority, and temporary and permanent primary physical custody of the children as determined in the children's best interests. Well, if everything y'all been doing thus far has been in their best interest, why does anything need to change now that y'all are getting a divorce? I'm so confused. Kandi been working all this time, so why does there have to be a custody issue or a custody counter suit claim, whatever? I'm not. Why can't y'all just agree on outside of the courts what's going to work best for the child? Okay, that the court determine all matters related to the minor children in accordance with OCGA 19-9-3 and 19-6-15. That husband be awarded an equitable division of the marital property and all appreciation thereon. That the parties equitably divide all marital debt. That husband be entitled to all additional relief including alimony and child support in the event that the prenuptial agreement is not enforced, that the court incorporate any settlement agreement entered into by the parties into any final judgment and decree of divorce, and that husband be awarded such other and further relief as this court deems just and equitable. Respectfully submitted this 26th day of November 2025. Old Randy M. Kessler, Esquire. Mr. Kessler, Mr. Real Housewives of Atlanta, Kessler. Okay, so that was Todd's answer and counterclaim for divorce and other relief. He wants them to divide the debt, which he probably accrued by himself. No, I'm just kidding. I don't know. I think he the one put them in debt with those restaurants. I do have a video regarding how much they owe in back rent or whatever for one of the restaurants. I forgot if it's Blaze or OLG. I think it's Blaze. Yeah, it's Blaze. I have a Kandi playlist if y'all want to, look into that. I'll be coming back with Kandi's amended response to this. But yeah, just in summation, Todd wants temporary and permanent legal custody of the children. He should be awarded temporary and permanent primary physical custody of the children. And he wants it to be known that Kelly's going to be away working, so the kids need to be with him. So again, nothing should change. If she's been working, like if she's on tour or whatever, and he takes care of the kids, fine. But because her schedule is, not a set schedule, like a 9 to 5, what could the agreement be? I guess he's saying because her schedule's not set, he needs to have the kids all the time. So that would, involve or allow for child support, for him. But yeah, y'all know Kandi cheap. Y'all know Kandi cheap. Y'all know Kandi try to help out the little man. But in this situation, she needs to me, in my opinion, and to lead attorney's opinion, she kind of needs to wake up and make sure she's getting proper representation. All right, y'all. So let me know what y'all think about this. Do y'all think Todd's entitled to full physical custody, child support, alimony, part of the house that, they've been living in for the last 11 years? Let me know what you think. Drop down in the comments. I'm glad I clicked on his video so he could kind of break things down for us non-legal beagles. All right, thanks for watching. Make sure you like, comment, share, and subscribe, and hit the notification button so you don't miss any of my videos. Bye.